Your Honor. Mr. Apperson, I've spoken with my client. He agrees that it's really not relevant in this case. So
Okay, well then my question is, did you read the one that has been provided to the court?
I drafted it, so yes.
Okay, does the state have any objections to it? I don't need to argue it. Is it in or is it out yet? I just want to know if there's an objection.
To which instruction? He just
The justifiable use of deadly force.
There is one part that I do have a problem with.
Okay, well get it out and let's look at it.
We're talking about the single instruction that Mr. LaFay sent. I have a copy of it. The part that I have a concern about is the part where it says reputation. If, in the last page, a few paragraphs up, if you find that George Zimmerman had a reputation of being a violent and dangerous person, you may consider this fact and whether he was the initial aggressor. There's no reputation evidence in this case. There's no reputation.
I'm sorry, I'm trying to figure out where you're reading.
The very last page of
Yes.
Mr.
I found a paragraph that says if you find that the defendant, is that the one you're talking about?
Yes, had a reputation. Right, George Zimmerman, if you find that George Zimmerman had a reputation.
Okay,
It's the last page.
I'm on the last page and I'm reading the paragraphs. I don't see the word reputation. Please direct me to it.
We may be looking at two different things. I'm looking at, you asked the defense to prepare the self-defense instruction.
I'm looking at what you emailed to me last night. Whatever you put in there, here, come up here.
Those are all, yes, you're right. Those are all the corrections that we went over yesterday afternoon. And then I asked if the defense can...
All I'm asking you to do is to tell me where in this piece of paper...
It doesn't. It's not in there because that's mine. This is the defendant's proposal.
It would be very helpful to me if when you're talking about something, I have it in front of me.
Your Honor, I brought a copy for the court. I did not have your email, sorry.
Well, I don't... Okay, first of all, it's a different font. It looks different.
That's time to be running 12.
Okay. Doesn't look the same, but... Now, this one has 3 pages, so which page are you talking
The
about?
very last page, a few paragraphs up.
Okay, now I see it. It's clear as day. It wasn't in the one I had. Okay.
Yes, and my objection is there's no reputation evidence in this case.
Okay, what's the reputation evidence? Because I think that the question that's asked is, do you have any knowledge of Mr. Zimmerman's reputation in the community for honesty or whatever? That question was never asked of anybody.
There's only one question that was asked about, Your Honor, and I'm going to just recite it for you. When my client was on the witness stand, I said, did you feel it necessary to tell Detective Hernandez that Mr. Zimmerman had shot and killed Mr. Martin when every single person in the nation, if not Florida, knows about it?
Well, that's not reputation testimony.
That's the only basis that I have.
Okay, well then it comes out.
Thank you.
So, where are we now in the instructions?
Otherwise, the instruction that Mr. LeVay proposed is fine. And what I did the liberty of is, if the court did strike that, I printed a copy of Mr. LeVay's instruction that has that out. So we can just simply insert this.
So, take away the one you put in the instructions, take away the one Mr. LeFay put in the instructions. Mr. LeFay, the one that Mr. Stone has in his hands, are there any objections to that one? If you'll please take a moment, please take a moment and review it. I want to make sure.
That's the one you
Have a
sent.
seat and really look at it. I want to make sure these instructions are important.
It is, Your Honor, word for word, the instruction that I drafted, minus the one offending paragraph on reputation, so I have no objection to it.
Okay, perfectly. Can I have a copy? And the state has no objection to it either?
That's correct.
Okay, I'll put that in here. Let's go through the other ones that were being changed so I can make sure that they are the correct ones.
Judge, this is the only copy that I have.
Well, what would you like me to do?
Can we make 2 copies so the court can have one?
Well, you can make 2 copies.
Where should I make the copies from?
Where do you have a copy machine?
I don't want to leave the courtroom, you're going to get mad at me. Like, that's...
Well, I'm not getting up to make the copy.
Yes, please. It would be quicker for me to go down there and come back up instead of Sarah coming up here, taking this, going back down and coming back up. So would I just run downstairs and make 2 quick copies of this?
Yesterday, you had said that Mr. LaFay was emailing it to you. Do you have it on email?
I did email it to him,
Oh, but you don't have a computer here.
Actually, yes, you got someone who's...
Thank you.
I think the last time Mr. Stone said he could make it up and back in 3.5 minutes. But
Well, he's got to give a closing. I don't want him to be out of breath. It wouldn't be fair. Okay, thank you. While they're doing that, could we spend this time going over the other instructions that were supposed to be corrected to make sure that everybody's in agreement with them?
Yes.
yes, Your Honor.
Okay, the first one was the attempted second-degree murder. I've gotten an amended charge that was to include the heat of passion. Is the new attempted second-degree murder acceptable to the state?
Yes, Your Honor.
Is it acceptable to the defense?
Well, you don't want the heat of passion,
He wanted it.
but I think you just said you didn't want it now.
Right,
No, we have to get rid of that one.
I had taken it out of the self-defense instruction.
So the original attempted second-degree murder, is there any objection from the state?
No
Do you have it?
I do have the original.
Okay, do you have any objection to that one?
No, Your Honor.
So I'll take out the one that I was just given today, and I'll put in the one from yesterday. Okay, let's see.
Judge, I don't have a copy of that.
You can look online.
Well, I'm going to need it for my closing argument. I mean, Mr.
Now
LaFay said he
my-
wanted it, and I put it in there, and now he's saying no.
Well, I don't have a copy machine in here, and
Completely messing me up.
you want a copy? Go get one.
I don't even see where it's inserted in attempted second.
It is. Here, right here, heat of passion. Well, can I borrow that one?
Yeah.
Yeah, but I...
So we have a copy for Mr. Stone.
Okay, great, thank you.
That's it? All right. Thank
The
you.
other one that was going to be changed was the improper exhibition of a firearm. It's been corrected to take out the bracket and the paragraph. So the new one, is there any objections from the state,
No, Your Honor.
from the defense? You had asked that the paragraph, if you find that the defendant exhibited the firearm in necessary self-defense, you must find him not guilty. That was taken out.
It says on your copy, Judge, I did not get a copy of the new edit, the new edition, so, but I understand they're coming up right now, so if that's what it says there, then I'm fine with that.
Well, I would feel a lot more comfortable if you physically looked at them and let me know that.
I'll look on Mr. Stone's copy. Is it coming?
Yeah,
It's fine. Copy of the final. I sent it after I left. I went home early last night, and so I left. I had dinner with my family.
You don't have a copy of it either?
I have a copy, but,
But I understand that you're bringing up a fresh set of copies for.
no, just for the self-defense.
Fine.
No, it isn't fine.
Can you
What-
ask your office to make a set, a fresh set?
Yeah, the answer is yes. But what I propose is, once we know exactly what the final instructions are, once we work through that, then I would just like to make a copy for Mr. LaFay, and
Well, but right now, we're trying to work through them, and
Yes.
Mr. LaFay needs to look at them.
I trust that Mr. Stone, Your Honor, I can tell you, I've worked with Mr. Stone for many years. I trust that when I look at what he has before him, which is before me right now, and I'm going to show it to my client as well.
and here's the self-defense instruction.
That those edits have been made. They took out the thing about self-defense here, which, so that is acceptable, Your Honor.
Okay, then the next one that was asked to be worked on is the justifiable use of deadly force.
And we just got that.
Okay, could you both please look at it and tell me if that's the one you want the court to read and if it's acceptable to both sides?
Judge, I'm not sure the court has a copy that that's the one.
I don't.
Here it is, here's a copy from the
Okay,
court.
I would like for both of you to look at it to see if that is acceptable to both sides.
Great. So, Your Honor, other than, of course, my objection for the record that the revocation paragraph is not within the justifiable use of deadly force, I have no other objections.
Okay, that objection is noted for the record, and I will not include it. So, and the state has no objections to that one either?
Yes, Your Honor.
All right, then the next one we were doing was weighing the evidence, and we were adding the one about number 7, has a witness been offered or received any money, etc. Is this instruction now acceptable to the state,
Yes, Your Honor.
to the defense?
I'm showing it to Mr. Apperson.
Please do.
Your Honor, so the defense has no objection to that.
All right, and then we were adding instruction 3.12A, single defendant, multiple counts or information. Is that acceptable to the state?
Yes, Your Honor.
To the defense?
And that's acceptable.
Okay, thank you. And then we were working on the verdict forms. Have you had an opportunity to see the new verdict forms?
I have not.
Okay.
Your Honor, also, I believe there were some changes to the enhancers.
Yes.
That's on the verdict forms. They're on the verdict forms. Right. So, if you can please give Mr. LaFay a copy of the new verdict form so he can review them with Mr. Apperson.
Would you like to look at my... Why don't you just take all three of them, and you can give them back to me?
Verdict as to count one is acceptable, Your Honor.
Okay.
See the signature lines on counts 2 and 3.
So are they also acceptable?
Count 2 is.
Okay.
Count 3, I believe, should have we further find that during the commission of the crime, the defendant did not actually possess. It's going to be consistent.
I think I put it in.
No.
I don't have it on.
You don't have it on count 3.
No, Your Honor, no one asked me to do that. The only reason why we did it on the other one is because the other one had 2 further findings, the reclassification and the 1020 life. On one of those further findings, there was the not and the yes, but on the other it wasn't, so I was asked to make it consistent on that verdict form. This verdict form, no one told me to do that, and I didn't. That's the only reason why we changed the first one, because there were 2 further findings on that one verdict form. So I wasn't asked to do that on this one, and I didn't.
Let me take my 5 minutes.
Okay. So are there any other changes to any of the instructions that we've gone over
Not from the statement.
from the defense? Are you the one who's coughing?
I'm sorry.
Are you okay?
Yes, I'm going to actually get some water.
Okay.
I have no other changes, and I actually have some leftovers from yesterday.
Do you want to look at my full set?
If I could, Your Honor, just to take 30 seconds.
Absolutely. Is there a way we can get Mr. LaFay a full set?
There is. But it's going to need me to go downstairs and make a copy, or I can give it to, we can copy it back there, but, yeah, the answer is yes.
Well, I think that under the rules, he's entitled to a full set of the jury instructions.
Oh, I agree 100%.
So let's get him one.
One will be coming. Just one copy, Your Honor?
I have my copy that's going back to the jury.
adjourned.
Need more time, you can have more time.
I've reviewed them, and I've checked the edits. So I've checked those, and
Okay,
thank you, Your Honor.
you're welcome. A copy is going to be given to you. Are we ready to bring the jury in?
I need my copy of the jury instructions. I'm going to refer to them, and I don't have them yet. They're being copied.
Well, you only set her down with one copy.
Yes, that's all I had. Square of the laser pointer, Your Honor. It might be on the...
It's here.
Thank you.
Thank you, DJ. Okay, Mr. Lefay, you have just been handed a full set of the jury instructions. Do you need a moment to go over them with your client?
Just one second, Your Honor. Your Honor, I've gone over the instructions with my client, and other than objections previously noted, I have no others.
Okay, thank you very much. Are we ready now to bring the jury in?
Yes, Your Honor.
Your Honor, case law requires me at various points prior to, I believe, the reading of the instructions and after to preserve my objections. I don't know if the court would just give me a standing objection or if you'd like that.
All your objections will be deemed to be preserved for the record.
Thank you.
You're welcome. States also, but that doesn't matter. Let's bring them in.
Jurors are present.
Good morning. Please be seated. Good morning, ladies and gentlemen, and welcome back. And while you're getting settled in, you get to hear my questions again. If your answer is yes to any of the questions, please raise your hand. During the overnight recess, did any of you have any discussions with each other or with anybody else about the case? No hands are being raised. Did any of you overhear anybody talking about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you read or create any emails, text messages, tweets, blogs, or social networking pages about the case? No hands are being raised. Did any of you use any type of an electronic device to go on the internet to do any independent research about the people, the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you drive by any of the places described in the evidence for the purpose of doing an independent investigation? No hands are being raised. Thank you very much. Yesterday, both the state and the defendant have rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to the arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. Mr. Stone, you may proceed.
Thank you, Your Honor.
You're welcome.
First, let me wish everyone a good morning. And Let me first also say, thank you for giving us your attention this week. It's a long week, and it's tiring, and we need your attention. We got it, and we all appreciate that, so thank you very much for that. What I would like to do is start out by saying something that may be pretty self-evident, and maybe not, but I want to start out on this, and that is your focus, and I say this respectfully, your focus must be on May 11, 2015, and the defendant's conduct on that date. That's what your focus needs to be directed at. Now, of course, you consider all of the evidence. The evidence is evidence, so you consider, you know what the jurors do. They consider the evidence, and they evaluate it, and there's some things that, after you evaluate, just because it's been admitted into evidence, you evaluate it, and there could be some things that you can completely reject, but you need to evaluate and think about it, and then you can reject it or not. But of course, you consider all the evidence that's been submitted in this case. But all of that is geared towards May 11, 2015, and the defendant's conduct, Mr. Apperson's conduct. Because it's so easy, with all the evidence in this case, it's so easy to get distracted and side, and that's the date that this thing happened. So obviously that's the date we focus on. So, having said that, let me move on. The very first thing that Mr. LaFay said in his opening statement was that this case involves just one single question, one single issue: self-defense. And I agree with him 100%. I agree with him 100%. So what I want to do is, I want to start out by talking about the self-defense and the jury instruction that you're going to get. And I'm going to put it up on the overhead in just a moment. And I want for you to please note that there's one prominent thing that stands out during that jury instruction. Please note the number of times in that jury instruction words such as reasonable, prudent, and cautious appear. Over and over and over again. And let me put it up. Reasonably believes. Well-founded, reasonable person. Reasonably believes. Reasonable, cautious, and prudent person. Reasonably believed. Reasonable. Reasonable grounds. Reasonably believed. Reasonably believed. Over and over and over again, that concept of reasonable, prudent, and cautious appears in the self-defense instruction. There is nothing that Mr. Apperson did during his encounter with George Zimmerman on Lake Mary Boulevard on May 11, 2015, that was reasonable, prudent, and cautious. Nothing. And that's what you got to be. That's what you got to be if you're going to use deadly force to defend yourself. And let there be no doubt that discharging a firearm, shooting a gun, is deadly force. Even if no one is hurt, even if the bullet misses, the mere act of shooting, discharging a gun is by law deadly force. With a .357 Magnum handgun, loaded with hollow point bullets at his side, Mr. Apperson chases, he pursues George Zimmerman down Lake Erie Boulevard. He admits he was following Mr. Zimmerman. He admits that. And the post office photos and video show Mr. Apperson pursuing Mr. Zimmerman. Look at that video. The photographs were showed quite often. The video a couple of times. I'm not sure the video was shown in regular speed. Maybe the first time it was. It was shown to you a number of times, I think, when it was reduced speed. But you'll have that disc when you go back and deliberate. And bring that bit back with you, and of course, and watch that video at regular speed. And compare. You'll see Mr. Zimmerman go by, and then look at Mr. Apperson just seconds later go by. And compare his relative speed to the other cars on Lake Mary Boulevard. And you will see that he whizzes by compared to the other vehicles. So he was going fast and he was pursuing Mr. Zimmerman. Is that reasonable? Is that prudent? Is that cautious? He pulls up right behind Mr. Zimmerman at the break in the median when Mr. Zimmerman is making the U-turn. Mr. Apperson still has that .357 at his side, and then he yells at Mr. Zimmerman, "You fat, excuse my language, motherfucker. You remember me? You fat motherfucker? You owe me one. I didn't press charges." With the .357 at his side, screaming that at Mr. Zimmerman. Is that reasonable, prudent, and cautious? Mr. Apperson admits that he was really mad. And remember, that .357 is right there at his side. He admits that he was angry. He admits that he was mad. And that .357 is sitting right there, wedged between the console, the center console, and the passenger seat. He could have easily diffused the situation. He could have easily diffused the situation and avoid any conflict by continuing east on Lake Mary Boulevard. But what does he do? When Mr. Zimmerman makes the U-turn, Mr. Apperson follows him, angry, mad, and with that .357 Magnum at his side. Is that reasonable? Is that prudent? Is that cautious? After Mr. Zimmerman makes the U-turn, what does Mr. Apperson do? He makes his U-turn, and he gets behind George Zimmerman. With that .357 still at his side, he could have pulled off to the side of the road. He, meaning Mr. Apperson, he could have pulled off to the side of the road. He could have found the first side street and pulled into that side street. He could have found the first place to find a phone. He obviously didn't have a phone on him. He could have found some other place, some convenience store, some store, and called 911. Remember, he did it twice before. On September 9th, 2014, and September 11th, 2014. He found the time to pull off somewhere and call 911. But he didn't. He didn't this time. He didn't on May 11, 2015. He didn't. He gets behind Mr. Zimmerman with that .357 still there at his side. Is that reasonable? Is that prudent? Is that cautious? He had it with Mr. Zimmerman. He had enough of George Zimmerman. That's what this case is really about. He's done. He's finished with George Zimmerman. This case isn't a case of self-defense. This case is a case of retaliation. He's done with George Zimmerman. He's finished with him. He's had enough of him. And now it's his chance to take care of George Zimmerman once and for all. That's what this case is about. He's through with him. Mr. Apperson is now behind George Zimmerman, and he claims that he pulled him to the right lane because all he wanted to do was to pass Mr. Zimmerman's truck. That's what he claims. But what does he do before, as he claims, before he sees George Zimmerman with a gun? As he claims, what does he do? He picks up his gun first. He admits that. He admits that he picked his gun up first. There was no imminent threat of death or great bodily harm at that time. He admitted that also. And if you remember in the interview that he did at the Lake Merritt Police Department, he admitted in his interview that picking up the gun and shooting all took place in one motion. Look at that video, and you'll see him demonstrate what he did. This is what he did. He was sitting in his chair at the Lake Merritt Police Department, and he says, I took the gun out like that and I shot. So all in one motion, picking it up and shooting. So Mr. Apperson shot at Mr. Zimmerman before he saw any imminent threat of death or great bodily harm. Is that reasonable? Is that prudent? Is that cautious? Is that self-defense? Or is that someone who just had enough of George Zimmerman and is now retaliating? That's what this case is about. I am done with him. I've had enough of it. And all the evidence is consistent with that. Mr. Apperson admits that the window into which he shot was completely up when he fired that shot. And the trajectory analysis by Ed Bigley and Leroy Parker, who has 30-plus years of experience at FDOE in crime reconstruction, crime scene reconstruction, including trajectory analysis, confirms this. So that's not an issue. That is not an issue at all. That front passenger window was up when Mr. Apperson shot into it. That is a given fact in this case. You cannot see through that front passenger window. It is impossible to see through that front passenger window. Look at all the photos of that window. It's impossible to see through those windows, the side windows and the front passenger window, standing outside looking in. It is impossible. Every witness in this trial who was with George Zimmerman's truck testified that you cannot see through that window from the outside. Officer John Paul, Michelle Hernandez, the investigator who arrived at the scene, and Ed Bigley, who did the initial crime scene analysis on the truck. You remember Captain Miles testified with the Lake Merritt Police Department. Captain Miles attested the two driver's side windows and the rear passenger side window with the approved tint meter. You couldn't test the actual window that the bullet went into because it was too fragmented. You have to, apparently you have to roll down the window to use one of those test meters to place the device over it, and you couldn't do that with that window. But they were all the same. You see the photographs, they're all the same. And you remember what the results of that tint meter testing was? The front driver's was 3%. And both rear windows, the rear side driver's window and the rear passenger's window was 4%. That means that 96, 97% of the light does not get through. It is a virtual curtain over that window. And you remember the testimony from Captain Hawes about what is the legal limit in Florida? I think it was 28%, which means 72% gets through, and I think 15% for some other window. But the 3% and the 4% is well below the legal limit. And they could have issued him a ticket. Cannot see through that window. It's impossible. Now, Officer Call's testimony is very significant with regard to that window tint, and let me please explain why. And I emphasize this testimony, Officer Call's testimony, with regard to the window tint. He was the first law enforcement officer, actually the first person to have contact with Mr. Zimmerman after the shot. The lighting conditions and the conditions of George Zimmerman's truck would have been identical at the time that Officer Call had contact with him, would have been virtually identical to the conditions of that truck at the time the shot was fired, just seconds before. Officer Call said that he could not see into that truck. You remember his testimony? He drove by it at first, and then it was flagged down, so Officer Call had a full view of that truck. He said he could not see into it. And once again, I ask you to recall his testimony, because he couldn't see into it. He became concerned. And you remember his testimony? He used the word, he took cover. That's the word he used when he testified. He was so concerned that he took cover, not knowing if there was a deadly threat within that truck. Now, here's an experienced officer. Was his testimony 25 years? Here's an experienced officer, 25 years police officer, who could not tell if there was a deadly threat inside that truck. And once again, I emphasize, the lighting conditions and the condition of the truck would have been virtually identical at the time Officer Call had contact with that truck, as compared to just seconds before when Mr. Apperson shot into that truck. If Officer Call, a 25-year experienced police officer, under the exact same lighting conditions as when Mr. Apperson shot into the truck, an officer who was specifically trying to determine if there was a deadly threat inside that truck, if he couldn't see into that truck to determine if there was a deadly threat in that truck, then Mr. Apperson couldn't. And remember this also about Officer Call. He had more time to analyze the situation. He had more time. I mean, he drove by, and then Mr. Zimmerman flagged him down, then the car stopped, then both vehicles stopped, he got out, he said he took cover. So he had time to scope that truck and look at it. He had time to analyze it. The shooting part of the encounter between Mr. Apperson and Mr. Zimmerman had to have happened very quickly. So Officer Call, who had time to check it, specifically trying to determine if there was a deadly threat in that truck, could not. If he couldn't, there is no way, no how, Mr. Apperson would have been able to see into that truck. Absolutely impossible. That's the reason why John Paul's testimony is critical and important for you to consider. And please do. Another observation about Mr. Apperson's testimony, that he could see through the window. He testified that he could see through that window. Well, let me make an observation about that. You'll get a jury instruction that's called weighing the evidence. And that instruction contains various factors to consider when you evaluate the credibility of a witness, any witness. Now, Mr. Apperson became a witness in this case, and in that same instruction, it will say, I'm going to put it up in a second, the defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. So when he took the witness stand, he's on par with all the other witnesses. You use the same criteria, the same factors to evaluate his testimony as you do with all the other witnesses in the case. Let me show you number 5 right there. Does the witness's testimony agree with the other testimony and other evidence in this case? With respect to Mr. Apperson's testimony, you can read it this way. Does the defendant's testimony agree with the other testimony and evidence in this case? Well, does it? With regard to the window? Well, it doesn't. And that's obvious, it doesn't. All the other evidence in this case, all the other testimony in this case, contradicts the defendant's testimony about that, seeing into the window, which is impossible. There's another part of that instruction, which may make it very apparent why Mr. Apperson says he can see into the window, while at the same time all the other witnesses and all the other evidence says no, you can't. Let me show you that. Number 4, does the witness have some interest in how the outcome or how the case should be decided? Well, just like with number 5, you can read that is, does the defendant have some interest in how the case should be decided? Because he became a witness. There is nobody on the face of the earth who has a greater interest in the outcome of this proceeding than does Matthew Apperson. That might tell you why he's saying, I can see into that window when no one else can. Now, regarding Mr. Zimmerman's testimony. Regarding Mr. Zimmerman's testimony, and keep that instruction in mind, that the number 4 that says, does the witness's testimony agree with the other evidence and the other witness's testimony in the case? With regard to Mr. Zimmerman's testimony, with respect to May 11, 2015, with respect to May 11, 2015, and once again, I can't emphasize that more or enough. You consider all the evidence, of course, but everything is geared towards May 11, 2015. With regard to Mr. Zimmerman's testimony, with respect to May 11, 2015, Let me talk about that for a moment. Mr. Zimmerman testified that Matthew Apperson chased or pursued him. Well, that's corroborated. The other evidence agrees with that. You have the videos, you have the video, and you have the photographs that confirm this. And Mr. Apperson admits it. So that other evidence and testimony agrees and supports Mr. Zimmerman's testimony. Mr. Zimmerman's testimony that Matthew Apperson called him a fat motherfucker. You owe me. I didn't press charges. Well, Mr. Apperson admits that he did that. And that admission, you can trust that admission by Mr. Apperson, because that's something that hurts his case. So we wouldn't say it if it wasn't true. So that supports Mr. Zimmerman's testimony. Mr. Zimmerman's testimony was that he made a U-turn, and then Mr. Apperson sped up and pulled right next to the right, next to his truck. Mr. Apperson admits that. And the video and the photos show that. So that supports Mr. Zimmerman's testimony. Of course, Mr. Zimmerman's testimony was that Mr. Apperson shot into the truck, and obviously he did. That's a given in this case. So obviously the evidence agrees with that testimony by Mr. Zimmerman. Mr. Zimmerman's testimony was that you cannot see. It's his truck, you know, and once again we're talking about May 11, 2015, that you cannot see through the windows. And once again, all of the evidence, except Mr. Apperson, all of the evidence, all of the witnesses, the tint meter supports that you cannot see into his truck. So with regard to the events on May 11, 2015, Mr. Zimmerman's testimony regarding those events of May 11 are corroborated. His testimony does agree with the other testimony, the other evidence in this case. An observation about Mr. Apperson's testimony and the contradictions between his trial testimony and the interview that he gave at the Lake Murray Police Department. Once again, regarding the events of May 11, 2015. At the trial, Mr. Apperson's testimony was that they will go on westbound. And that's true. All the evidence, they will go on westbound on Lake Murray Boulevard. In his interview, he has them going eastbound. And look at that interview. There is no question. Look at that interview. With hand gestures and the way that he's talking, he has them going eastbound towards that 7-Eleven on North Country Club Road. There's no doubt that's what he's saying on that video when he makes his hand gestures about the U-turn and continuing down that way. He has them going eastbound. That's the contradiction, inconsistency in this testimony regarding May 11, 2015. In his trial testimony, he says that he's going to the 7-Eleven on Reinhardt Road. Well, it's clear in the video statement that he gave, he said that he's going to the 7-Eleven on North Country Club Road by the railroad tracks, eastbound on Lake Murray Boulevard. This is important. In his interview, and once again, it's not a long interview, it's about maybe 5 or 6 minutes. Please listen to that. Please play it again. Look at Mr. Apperson's account of the encounter that he had with Mr. Zimmerman. Just look at his encounter. His description of his encounter. He has them driving down eastbound, the wrong direction, the eastbound direction of Lake Murray Boulevard, just casually driving. And the next thing you know, George Zimmerman pulls up to him, has a gun pointed at him, and says, "I'm going to kill you." Just casually driving to get a pack of cigarettes. And look at what really happened, how the encounter occurred. Going westbound, speeding, taking place after the U-turn, very quickly, after the encounter or the exchange at the U-turn. A completely different account of what occurred. At the time he gave his interview at the Lake Mary Police Department, he had no idea that, by chance, a surveillance video caught that. He had no idea at that time. But I ask you to please listen to that interview and watch it again, and particularly when he describes, it gives a description of the encounter. Just casually driving down Lake Mary Boulevard, and this man that I know before just pulls up to me and points a gun, and I'm going to kill you. Completely inconsistent with what really happened. Now, let me talk about attempted second-degree murder. Mr. Apperson is charged with 3 counts: attempted second-degree murder, shooting into an occupied vehicle, and aggravated assault. And I do want to just say some things about attempted second-degree murder. Okay, that got the whole thing, actually. The only thing above that, it just simply says, right above that, it just simply says attempted second-degree murder. So this is the whole instruction right there. Every crime in the state of Florida, for that matter, probably every state, but every crime in the state of Florida has a definition. And the way that it's defined is it's defined by what are called elements. Every crime, whether it be misdemeanor littering or first-degree murder, they're defined by what are called elements. Some crimes have 1 or 2 elements, others have 4, 5, or 6 elements. These are the elements of second-degree murder, 1 and 2. The other things are definitions, and I'm going to talk about those. But this is the definition, the elements of second-degree murder, 1 and 2. The first one, Matthew Apperson intentionally committed an act, shooting into the truck, committed an act which would have resulted in the death of George Zimmerman, except that someone prevented Mr. Apperson, Matthew Apperson from killing George Zimmerman, or he failed to do so. It's actually this. I mean, that's an attempt. An attempt is you try to do something and either someone prevents you or you just simply fail. In this case, I guess you can forget about the preventing. He just failed. That's the type of attempt in this case. He tried to do something and he just simply failed. That's any attempt. If someone prevents you, which didn't occur in this case, then that's another way of an attempt. But this case is really the failure to do so. And the second one is the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. Those are the 2 elements right there. And underneath, it says, and now there are definitions underneath. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. In this case, there was really the one main act of pursuing him and driving up and shooting into the truck. Then an act is imminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts. And in this case, it's the main act of shooting into the truck. That a person of ordinary judgment would know was reasonably certain to kill or do serious bodily injury to another. is done from ill will, hatred, spite, or an evil intent, well, just seconds before he shot into Mr. Zimmerman's vehicle, you fat motherfucker, that kind of indicates ill will and hatred, you would think. Evil intent, and is of such a nature that the act itself indicates an indifference to human life. And I'll talk about that in 1 second, but underneath it says, in order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. In other words, that would be first-degree murder. If you intend, that's your design, to kill someone, and you kill them, that's first-degree murder. Second-degree murder is just a depraved mind, indifference to human life, and you do something. And you fail to accomplish it, which is an attempt. So, indifference to human life. What Mr. Apperson did was really outrageous. He just blindly shoots. And I emphasize the word blindly. He cannot see into that window, into that truck. He can sit there all day and say he can see it. He didn't see it. It was impossible. He blindly shoots through the passenger window. Just think about that for just a second, or when you go back, think about it more than a second. Although you probably just need just a second to think about it. If that shot was a little lower, at least two very bad things could have happened. The first bad thing is that it would have hit Mr. Zimmerman in the head and he would have been dead. But the other bad thing is, if it missed Mr. Zimmerman and it was a little low, it would have went out that driver's side window. Now think about that. At Lake Mary Boulevard, at 1 o'clock in the afternoon. Think about that. It could have easily hit someone going eastbound. It could have easily hit a passenger or a pedestrian walking on Lake Mary Boulevard. Look at that surveillance video. Watch that surveillance video. And you know what you'll see? You'll see some guy riding on a bicycle going across the entrance to the post office.
Your Honor, I'm going to object. These are facts that are not in evidence, nor are they charged and relevant to the charges here.
The jury is welcome to review any of the exhibits that are in evidence and make a determination for themselves.
That demonstrates a depraved mind, regardless of human life. Just think about that, how outrageous that is.
Your Honor, I'm going to object again. That's a mischaracterization of the law, and I would have to approach.
All right, you may approach. Ladies and gentlemen, I will read the instructions on the law to you. They do happen to be up on there, but I will be reading them to you. I'm asking you to, the defense motion to strike the comments about depraved mind are granted, and you're to disregard them.
The second count is shooting into an occupied vehicle. And once again, this is defined, as all other crimes, this is defined by what are called elements. Let me put that up of the overhead. Three elements. Matthew Apperson shot a projectile that would produce death or great bodily harm. He did so at or into a vehicle that was being occupied by any person. The act was done wantonly and maliciously. And then there's definitions of wanton and malicious. Well, that's what occurred in this case. Once again, the remark that was made just seconds before he shot into the vehicle. That was malicious. Wanton means consciously and intentionally and with reckless indifference to the consequences, and we acknowledge that damage is likely to be done to some person. Once again, shooting into that vehicle demonstrates the maliciousness and the wantonness of what occurred, and that's exactly what happened in this case, and that's the second count. The third count, aggravated assault. First element is this is count 3. Matthew Apperson intentionally and unlawfully threatened either by word or act to do violence to George Zimmerman. Well, he did that by pointing the gun at him, which George Zimmerman did see. You can see out, but you can't see in. At the time, Matthew Apperson appeared to have the ability to carry out the threat, or he certainly had the ability, and he did carry out the threat. The act of Matthew Apperson created in the mind of George Zimmerman a well-founded fear that violence was about to take place. It absolutely, certainly did that, and violence did take place. And the assault was made with a deadly weapon. And obviously, a deadly weapon was used in this case, the gun. And just as in attempted second-degree murder, it is not necessary that there be an intent to kill. Now, let me talk about reasonable doubt for just a couple moments. And the first thing that I want to emphasize is that the standard is beyond a reasonable doubt. Not beyond all doubt to an absolute certainty. You know, we've all heard the expression beyond a shadow of a doubt. That does not exist in the real world, at least in the real courtroom. It doesn't exist beyond a shadow of a doubt. Burden of proof is beyond a reasonable doubt. Judge Nelson will instruct you about the reasonable doubt instruction. And you'll note, and I think actually Judge Nelson did read that instruction to you earlier before the trial. And you'll note that the reasonable doubt is not a possible doubt. It's not an imaginary doubt. You know, it's possible, maybe, it's possible he wasn't going after him. Or I can imagine, I can force a forced doubt. It's not a forced doubt. It's not a speculative doubt. Oh, it's possible. I can imagine. I can force myself, to believe that he wasn't going after him. Like he, meaning Mr. Apperson, going after George Zimmerman. I can force myself to believe that. But if those are the only kind of doubts that you have, and I respectfully say to you, based upon the evidence, with regard to May 11, 2015, that those are the only kind of doubts that you can have. Those are not reasonable doubts. And Judge Nelson will tell you that if you have a forced, imaginary, speculative doubt, or a possible doubt, that those are not reasonable doubts and they should not influence you to find the defendant not guilty. Another thing to emphasize about the reasonable doubt standard is that it only applies to the elements of the offense. The number 1, the 2, and the 3. The numbers, the elements of the offense. There may be some things about this case that you have doubts. There may be some things about this case that you have reasonable doubts. How fast were they going when Mr. Apperson shot into George Zimmerman's vehicle? Were they going 40, 45, 50 miles an hour? We don't know. You certainly have a reasonable doubt about that. How far were the vehicles apart? 3 feet, 4 feet, 5 feet? Don't know. Certainly have a reasonable doubt about that. What are the VIN numbers on the vehicles? The vehicle identification numbers? Have no idea. Certainly have a reasonable doubt about that. But those things are not elements of the offense, and the reasonable doubt standard only applies to the elements of the offense. The number 1, the number 2, the number 3, the number 4. Now let me talk about Mr. Apperson's testimony about George Zimmerman. Well, he got out everything under the sun about George Zimmerman. And if you were a cynical person, you just may think that the defense is trying to put George Zimmerman on trial. And just forget about Matthew Apperson. But no.
Objection. And again, I have a motion, and Your Honor, I have to approach.
It's approach. Ladies and gentlemen, I normally don't like to do this during a closing argument, but there has come up a matter that may take a few moments. So if you'll please put your notepads face down on the chair and follow Deputy Debs back into the jury room.
I just researched this in a 38, 50 minute meeting, but if I could call my office and ask my assistants within the body of that motion for the, I believe I cited the case law within it.
Okay, do we do so? Mr. Stone, I apologize for having this break during your closing argument, but while he's looking that up, I would ask that Mr. Flynn find that case on his computer so you will be able to read it. So let's be in recess for 10 minutes.
Yes, sir. Thank you.
Mr. Apperson is asked to go for the rest of the
He may be brought back to do so.